Check one, check one, two. Check one, two.
saw it, huh? Oh, that's right.
And I also saw it on Facebook.
Oh, right, because they put it on the city thing.
Yeah. Ooh, it's so cold in here.
I'm so surprised they're saying that.
You do?
Yeah.
I think it's because you're amped up. No, it's okay.
Possible.
It's cold in here.
Yeah?
Yeah.
Huh. Benefits of being amped up, I guess.
No, it's okay. So, we don't have a queue tonight. So you're just gonna have to control. Oh yeah, how are we gonna say we wanna stop?
We didn't have till like 2 years ago, and they were able to do it.
Well, now I can't function.
You just kind of raise your hand and then tell us if you want to talk more than you think about it.
Joyful month.
Flag you down.
And I used to
Joy actually writes quite well. Look, it says joyful month. I'm sorry that I can't write very well.
Someone wrote
Helped
for
her,
her. This
right.
is her.
That's
Yeah.
her.
She can't see anything.
Yeah, and they're like, what?
She's very intelligent.
No, I knew that she
Yeah.
was very,
Yeah.
articulate and all that
Yeah,
stuff, but,
yeah.
she's not that way when she comes to speech
I know.
now. So
Yeah.
this is another coherent, so I'm sure
Yeah.
that it was edited.
Yeah.
Yes, I do.
Got enough room there? You need more room than I do.
Should be fine.
Hey, you'll never know.
Probably got lost.
Good evening, everyone. Am I on? Can you hear me?
Very good.
Am I on?
Yes.
Better? Okay, very good. There I am. Good evening. The November 9th, 2017 Rent Control Board meeting is called to order. Would the secretary please take roll? Here.
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 I am here. Okay, please join me in the salute to our flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Just a note, if anyone wishes to address the board, either on a specific item tonight that's on the agenda or a public comment, please make sure that you see our secretary fill out one of these slips so that we can put you in the queue to speak. Okay, can I get a report of the closed session, please?
Yes, good evening. Good evening, Commissioners. I'm not sure whether, there we go. I understand that things work somewhat intermittently, so I'm not sure whether it is going to, whether this will work for anybody who's not in the room, but the board considered two items in closed session. They were both items related to litigation. The first item was concerning pending litigation. The issue was whether to authorize the General Counsel to enter into a settlement of costs. The board voted unanimously to authorize the General Counsel to enter into a settlement of costs. The other item was also an item of litigation, two items of potential litigation, and no reportable action was taken.
I was going to say. Yeah.
Sure.
You and I can.
Okay, well, we can use this. Oh, we can use this.
Okay, thank you, Mr. Lewis. All right, moving on to item number 5, approval of the minutes. May I have a motion to approve the minutes of the board's last meeting?
I've reviewed the minutes, so I'd like to make a motion
Okay, it's been a first and a second. I'll take, any discussion? No? Okay, I'll take all in favor of approving the minutes? Aye. Any opposed? Okay, the ayes have it. The minutes of last month's meeting are approved. Okay, special agenda items. Are there any special agenda items to be discussed?
Yes, Commissioners, I'd like to bring two upcoming meetings to everyone's attention. The first is the City Information Session on the Seismic Retrofit Program, which will be taking place this coming Monday in the evening between 6 and 8 here at the East Wing Civic Auditorium. The city will be hosting the first of 4 seismic retrofit informational meetings with the community, and the meeting is scheduled for 2 hours. It'll be an opportunity for building owners and tenants to get information about the seismic retrofit program, as well as ask questions of city staff and also design professionals regarding the program. Parking validations will be available for attendees, and additional meetings on this topic will take place throughout the coming year as more retrofit notices are issued by the building department to specific property owners. And I would also like to bring to your attention the 4th Annual Landlord-Tenant Forum that's going to occur on Tuesday, December 12th at 9:30 in the morning until noon. That will take place in the main library at the MLK Auditorium. This forum is co-sponsored by the Rent Control Agency and the Consumer Protection Division of the City Attorney's Office. We'll spend that morning covering hot topics in Santa Monica, landlord-tenant issues, and this is part of the city's ongoing effort to increase public awareness in and of the impact of state and local laws on Santa Monica tenants and landlords. Some of the topics that we're talking about will include tenant protections during construction, online tenancy registration, and the rent control information sheet requirements that the board passed for new tenants. The City Attorney's Office will present on privacy issues, such as the use of security cameras and concerns regarding tenants' immigration status, and representatives from Building and Safety will present on the city's recently implemented seismic retrofit program at that meeting as well. All tenants, property owners, property managers, and advocates are invited to attend. You may visit www.smconsumer.org for online registration, or you can call the City Attorney's Consumer Protection Division to register by phone, and the phone number is 310-458-8691. And those are the special announcements.
Thank you very much. I believe Commissioner Terosas had a comment.
This isn't our usual setup. If I could just make a request that, if not done so already, that both of those are placed on both our website and Facebook page so that the members of the public can see them, and members of the public out there, if they want more information, they can go online to our Facebook or website.
Thank you.
Thanks.
Comments from any other commissioner? No? Okay. Moving on to public comment, which is number 7. This is the time set aside for members of the public to address the board on matters that are not included on the agenda, but that are within the board's subject matter jurisdiction. Please note the board cannot take any official action at tonight's meeting on any matter that is not included on the agenda. I do have one request to speak from Nicholas Gross. If you would go up to the podium. And before you get started, I believe there's 3 minutes. Is that correct? Okay. You have 3 minutes.
Can people hear me? There we
Perfect.
go. I brought my boys here today from Franklin School because there's no school tomorrow. Just a quick situation that I want to inform. First of all, I understand today is not a hearing, and tonight's not a hearing, and there are no decisions or votes happening. But something I felt was important because I already discussed it with the Apple geniuses, as well as did a lot of research. And I don't want what happened to us to happen to anybody else. The timestamps and the date stamps on iPhone photos can be altered, can be changed very easily. You just download your pictures into your computer, can change the times and dates, you send them back to your phone, and they'll appear in your phone in the date order that you have made the changes to. I've turned in this article, How to Change the Timestamp on an iPhone Photo, inspired by the Vanderpump Rules. You know, whether you can understand this or not, whether photos are altered or not, is not the issue. It's whether they can be. And iPhone photos, especially in the phone, they're not admissible evidence. Issues shouldn't be decided on anything like that. It's not whether people alter them or not. It's whether A, the evidence is admissible, which it's not, and B, can the timestamps and date stamps be changed, which they can. They can be done very easily. I've had a lot of cases, and you know, this is what the Supreme Court has decided. As far as using photographs for foundation, that's acceptable, but the photograph itself has to contain the date and the time that the photo was taken. And then if you want to use the metadata as the next best evidence rule, as backup, if they match, then you can reach a logical conclusion. But the time and the date stamp need to be in the photograph itself. So hopefully, not just in our 3-2 vote, but anybody else who runs into this issue with the board will see the research which has been turned into your office already and to Lonnie, and understand that it's not admissible and not decide issues on an issue of misdirection, which is really the case here. And hopefully in a few months we'll get another hearing, and the judges will, or the hearing officers will convene, and the board this time will agree with the judges or the hearing officers who take months and months and are never going to call somebody a criminal, but they'll just say, hey, we don't give this much weight. Judge Nabeloff knew what she was doing, and Judge Hollingworth knows what she's doing. That's why, and the two attorneys know what they're doing. They take months and months with these cases to get it right, and then you guys have so much work to do, you only get to see things for a few minutes and make a snap decision. If anything, I feel that the board should take things under submission, talk with the attorneys, review anything additional. If they're going to take additional evidence from one side, they should certainly let the other side rebut, because this board's not supposed to take any additional evidence at these type of hearings. So anyways, hopefully we'll see in a few months, and I hear my time's up, and I want to thank everybody for your time, and I want to thank everybody for looking into our case and seeing our children. That's the final thing. We're talking about living beings here, pets,
Thank
children,
you, Mr. Gross. Mr.
wives,
Gross,
kids.
I
Right?
appreciate your comment. Your time.
Thank you very
expired.
much.
Thank you very much for making your comments. Okay, there are no more requests to speak in public comment, so I'm closing. Oh, I'm sorry, I didn't see you. Go ahead, Commissioner Phyllis.
So I believe this item was, or this issue was brought up in relation to a decision that was made last month with regard to an owner occupancy exemption. And I believe you're already aware of this, but for all members of the public, if there's an owner occupancy exemption that's been granted, and then for any reason there's evidence that the owner occupancy exemption has lapsed, then the owner occupancy, that will be adjudicated by the hearing officer. There will be recommendations made to the board. So if that has happened, there is a process to address it.
Thank you. Thank you very much. Anything else, Commissioner? I'm calling for order. Thank you. Okay, moving on to section number 10, jurisdictional items. Number 10A is an exemption owner occupancy. Number 1765, the address 2467 and 2469 Hill Street. Applicants D. Minor and M. Minor. May we have a staff report, please?
Commissioners, Mr. and Mrs. Minor inherited 2467 Hill Street when their son passed away in September of 2014. They own the adjacent single-family home at 2461 Hill Street where they live. The rent control law considers contiguous lots under common ownership as one property for the purposes of an exemption. And because the Minors own two contiguous lots with a combined total of 3 or fewer units, they're eligible to apply for the exemption of 2467 Hill Street if the evidence shows that they reside on the adjacent contiguous lot at 2461 Hill Street as their principal residence since at least April 17th of 2017. They submitted utility records, financial statements, and government records that show they have resided at 2461 Hill as their mailing address during this period. While they own a property in Los Angeles at 3435 Jasmine Avenue, they submitted leases and rent rolls to show that the property is rented and not used by them as their residence. DMV voter registrar and City of Santa Monica water, sewer, and trash records also show the property as the minor's address. The tenant at 2467 Hill Street confirmed that the minors reside at 2461 Hill, and because the preponderance of the evidence in the records show that the minors have met the requirements for the exemption, staff recommends that the board grant the application and adopt the findings of facts and conclusions of law that are attached to the staff report.
Okay, thank you. I see that there's been no requests to speak. All right, I would entertain a motion or begin deliberation. And I hear a motion. Go ahead, Commissioner.
I would make a motion that we accept the findings of our agency and that they have met the requirements, and express the board's sympathy for the loss of their son and let them get on with their business. I would move that we accept the recommendation.
Second.
Okay, there's a first and a second. Any further deliberation? Seeing none, I'll take a roll call vote.
Yes.
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 Yes. Okay, moving on to item 10B.
Commissioners, the petitioner in this case is the tenant Salim Riaz, and he's also the appellant. And before I begin, Mr. Riaz, the appellant, has requested a continuance of this hearing. Board regulation specifies that a party may request a continuance if the party can show good cause, makes the request in writing at least 72 hours prior to the board meeting, includes acceptable alternative dates, and provides an explanation of efforts made with all other parties to arrive at alternative dates. This procedure is clearly outlined on the notice of the appeals hearing that is sent to the parties with the decision. Mr. Riaz confirmed to staff that he received the decision and the notice in this case in time for him to have complied with the 72-hour requirement, yet he did not comply with the procedures for a continuance. Instead, he called and left a message with hearing staff on Monday, which was inadvertently deleted. Then he called legal staff yesterday, the day before the hearing, to request a continuance. He then wrote staff an email asking for the continuance, and he stated that he can't attend tonight's hearing because he's in Texas for work. Because Mr. Riaz failed to comply with any of the requirements for a continuance, staff could not grant his request. However, the board may decide whether to grant his request. The regulation 4026A states that a majority of the board may grant the request if there is a showing of good cause for the continuance and good cause for the basis of a late request. It should be noted that there is no evidence that Mr. Riaz has contacted the other party to this matter to arrive at an alternative date. The only alternative date in Mr. Riaz's email was in Thanksgiving week when there is no board hearing. So were the board to continue the matter, it could not be heard any earlier than the December meeting. But that's the first decision that you need to make in this case.
Okay, and just to make the record clear, this is item 10B1, and the case number is D4965. The address is 801 2nd Street, Unit 313, and the appellant is S. Riaz. I will add that there is a request to speak on this matter by a Mr. Charles Brickers. So.
Move to deny the continuance.
Wait, I have a question.
Okay, wait. There's been a motion to deny movement of the meeting. Is there a second?
Second.
Okay. No. There's been a motion and a second. Now, any questions?
Can I ask some questions from council? So 72 hours in advance, right? So that would have been Monday. Why was the message deleted?
It was just inadvertently deleted.
Okay, so potentially staff deleted it?
Right. It was sent to a hearing staff, not the legal staff, but it was sent to another staff, and that staff inadvertently deleted.
Did Mr. Riaz submit proof that he's in Texas for work?
He did not.
Okay, thanks. And is the other party here?
Possibly the gentleman who is
here to speak? Who's here to speak on this?
Is there Charles, is it Brackens?
Oh.
Oh,
V2,
okay,
yeah,
okay.
not that one.
Never
Yeah.
mind. Thank you.
So
Sorry
no
about
one's
that.
here on
No
this.
one.
Okay.
Okay, no one's here on this item. Okay, very good. There's been a motion and a second to deny the request that we continue this. Any further deliberation among commissioners? No? Okay. Why don't we have a vote on that motion? Yes, Commissioner Phyllis moved, Commissioner Foster seconded.
Yes.
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 No.
No.
Okay. Commissioners, Mr. Riaz has appealed the hearing officer's decision in this case because the hearing officer declined to grant him a decrease for allegedly unlevel floor in the kitchen and the dining room. The board reviews this matter as an appellate body, so it may overturn a hearing officer's decision only if it's based on factual findings that no reasonable person would understand to be supported by the evidence or on legal conclusions that are clearly erroneous. This appeal raises no claim of legal error, and staff believes that the evidence reasonably supports the hearing officer's factual findings. The board may grant a decrease for the allegedly unlevel flooring if it's a violation of a housing, health, or safety code, or the condition has materially worsened since the commencement of the tenancy when the rent was established. There is no evidence of either being the case. Mr. Riaz's apartment is less than perfectly level. The owner's agent conceded that. The hearings investigator placed a level on the dining and kitchen floors, and it showed them to be at a slight angle. But there is absolutely no evidence that this is a code violation. That is not surprising because even a video that Mr. Riaz submitted that shows him sitting on a wheeled chair on the floor only shows the chair rolling for a short distance before it stops, and even then, only when Mr. Riaz propelled the chair forward by pushing off the floor with his feet. There is no evidence in the record or even a claim that the slant in the floor is any different than when the tenancy began. So neither basis for a decrease is met by the evidence in the record. Mr. Riaz also asked for a decrease for the unlevel floor in the living room. Because Mr. Riaz never raised this allegation in his petition, the board is precluded from granting any decrease for the condition, even if there was any evidence to support it, because it would violate due process. Finally, Mr. Riaz has submitted new evidence with his appeal consisting of emails in which the landlord offers to reduce his rent by $20. These emails were sent 7 months before the hearing, yet Mr. Riaz never submitted them to the hearing officer. And the board receives new evidence in an appeal only if the party wishing to introduce it could not have presented the evidence to the hearing officer through the exercise of reasonable diligence. That is not the case here. So the board should not consider the new evidence, and for these reasons, staff recommends that the board affirm the hearing officer's decision.
Okay, there are no requests to speak. I am willing to entertain any discussion or motions, and I know that Commissioner Foster has some comments.
Thank you. I feel that the staff report is very direct and straightforward, and as a matter of fact, when you see a landlord behaving in such a normal and forthright and diligent fashion as the emails do illustrate, from start to finish, many things were addressed right after they were asked for. You know, that's the exemplary, normal course of business behavior we like to see. And I think that the staff's report is clear, that the items that were denied were firmly denied with obvious evidence, and I don't see any reason why we shouldn't affirm the board's decision and deny this appeal. So I'd be ready to entertain a motion, or to make a motion if no one else wants to discuss.
Yes, there is. Commissioner Trosas would like to make some comments.
I would just say that I agree. I didn't see anything in the record to show a reduction in housing service, the slanted floor. In fact, I didn't see anything to show how the slanted floor was any different than when the tenancy began. And I would concur with Commissioner Foster. The emails and the underlying records serve to show the reasonableness of the landlord.
Nicole.
Okay, Commissioner Phyllis.
Move to adopt the findings of facts and conclusions of law in the staff report.
Okay,
Second.
There's a first and a second by Commissioner Foster. We'll take a roll call vote.
Yes.
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 Yes. Okay, now moving on to item, excuse me, 10B2, which is case number N0254, 418 Pier Avenue, Unit 204. The appellant is S. Wendell. May we have a staff report, please?
Yes, Commissioners, Regulation 3304 allows landlords to petition the board to find that a tenant no longer lives in a unit as their usual residence of return, which would make the tenant a tenant not in occupancy, and which requires the unit's maximum allowable rent to be reset according to a formula based on recent market rents of comparable units. Courts have recognized that this regulation was designed to ensure that the beneficiaries of the rent control law are those who reside principally in their unit. The rent control law was not intended to maintain affordability in a secondary residence. Mr. Sam Wendell moved into Unit 204 in this property in the mid to late 80s and worked in the entertainment industry here. In 2001, his mother's health deteriorated in Canada, and Mr. Wendell moved to Montreal to take care of her. He first rented a room, and then he eventually bought a condo in Montreal in 2005. He founded a production company there, and he began teaching at university there. He then declared Canada to be his primary residence and qualified for a national health insurance card in 2007. The following year, his mother passed away. But Mr. Wendell remained in Montreal because his extended absence from Los Angeles had made it difficult for him to find work in the entertainment industry here. The evidence in the record shows that Mr. Wendell has spent anywhere from 1 to 3 months a year in his Santa Monica apartment over the last several years. Regulation 3304 is explicit that a tenant's failure to carry on basic living activities in his apartment for extended periods of time is evidence that he no longer resides in the apartment as his usual residence of return or principal residence. The only exception is for military service, vacation, hospitalization, family emergency or family care, sabbaticals, or temporary and seasonal work. Since 2008, Mr. Wendell has spent less than 3 months a year in his Santa Monica apartment because he can't find work here. That does not qualify for an excused absence under the board's regulation. To the contrary, the record contains ample evidence that he resides in Canada as his principal residence. He owns a condo in Montreal where he lives, and he represented that Canada is his primary residence to the Canadian government in order to qualify for national health insurance. The hearing officer therefore followed the law and readjusted the rent in accordance with Regulation 3304, and that decision is reasonably supported by the record. Staff recommends that the board affirm the decision.
Okay, I have one request to speak before we ask the speaker to come up. Are there any questions about the staff report by commissioners? Seeing none. Okay, Mr. Charles Brackens, I believe. You've asked for 3 minutes, so whenever you're ready, we will get started.
My understanding the fellow's not here, so I'll be very brief. If it's appropriate, I would just like to ask to confirm that the appellant did not submit any additional written evidence by last Monday. I didn't receive a copy of any, but I wasn't sure if he might have submitted something. I just wanted to make sure nothing was added to the record.
There was a written response that was submitted that's been provided to the commissioners, but there's no new evidence that was submitted by the appellant.
Okay. Okay. Then I would like to point out that my client, Andrew Sherwood, a representative of Pier Apartments, is here. And I would respectfully submit that I believe that Mr. Wendell is not here, and I think that that constitutes really a tacit admission that the hearing examiner and the staff report are accurate and should be affirmed. And that's really all I'd like to say. Thank you.
Okay, thank you very much. There are no other requests to speak. I have comment. Commissioner Phillips first.
Well, we're in discussion now, correct?
Yes, we are.
Okay. You know, I think the report is really clear. If someone has established residency for the purpose of getting national health insurance, I think that's a pretty persuasive evidence that they are not a tenant in occupancy here. You know, rent-controlled apartments are not intended to be summer homes. They're intended to be permanent residences, and this is exactly the reason why we have this provision. So I'm ready to move the item, adopt staff's findings of fact and conclusions of law when my fellow commissioners are ready.
Okay. I know Commissioner Phillips has asked Commissioner Foster has asked to speak. Go ahead.
So I agree with Commissioner Phillips, and I'm ready to proceed with that as well. But I have a question for staff regarding the regulation in general. And it's actually something that the appellant brought up in their letter that just made me think of it as a question. So ignorance of the law is never an excuse. However, I'm wondering if, in the context of Measure RR, wherein tenants, for instance, are given an opportunity to correct a perceived violation of their lease, or there's an opportunity for a curative period. So, under this particular regulation, would it be reasonable to assume that there would be a warning potential, like, in other words, communication between a landlord and a tenant, wherein the landlord asks the tenant, do you in fact live here anymore? Or is it just instantaneous that they file this action with? I've never seen one of these cases before, so I want to know, does the landlord just simply file this with us and we investigate and prove it and it's just over with? Or is there a curative period? I'm just curious procedurally how it works. I have no issue with this case whatsoever. I'm just asking about procedure.
The first part of your question, Measure RR has nothing to do with this because that concerns the termination of a tenancy. In this case, there's no issue of the continuation of the tenancy. The tenancy continues. Just the question.
No, I understand. That's context.
The landlord is just required to file an application and prove his or her case. There's really nothing to cure because it's just a factual inquiry. It's not. They're not claiming that they did something wrong.
So his letter asked, what is the time frame? There is no defined time frame, and is that in fact, I just want the public to understand, because this is a learning opportunity for people to understand about this maybe little known regulation. People should be aware of it, I feel, and public outreach is always a good idea. I'm just trying to address the topic as in a general way. Is there a timeline, or is it always subjective?
It is somewhat subjective, but there's ultimately a question of, did the person give up the property as their principal place of residence and have a principal place of residence elsewhere? That is, I wouldn't say wholly subjective, but I would say it's very fact-driven. It's not, there's not, I couldn't say that if somebody's away for 6 months that they lose their tenancy. It depends upon what are the reasons for being away, and those reasons are enumerated in the regulation itself. There are some cases that are very clearly not a cessation of permanent residency, and some that are on the other end that clearly are. I believe this is in the latter case. But there certainly are cases that are gray areas that are difficult.
Okay. I just thought as a matter of public outreach, that's just a very little known and not often discussed part of our law. And this was the first case in 2 years I've had come, in this regard. So thank you.
Thank you very much. Commissioner Trosas.
Thanks. I think, just for me looking at the facts, obviously this is a fact-based test, but the fact that he's been away since 2001, really what was dispositive for me was the fact that he bought a condo in Montreal, and in the last 9 years, since his mother's death, he's never spent more than 1 to 3 months in Santa Monica. And I really just, again, ignorance of the law, like Commissioner Foster said, is no excuse. I also think inability to find work in Los Angeles is not an excuse, unfortunately. he hasn't proved any intent to return to this place as his principal place of residence. So for all those reasons, I would agree with the staff report.
Okay. Anybody want to make a motion, or is there further discussion?
Did Commissioner Phyllis want to do that?
Move to adopt findings of fact and conclusions of law.
Okay, there's a first, second. Commissioner Tarosa seconds. Any further discussion? Seeing none, can we have a roll call vote?
Yes.
Yes?
Yes.
Yes.
Yes. Okay, now we are done with section 10. We're moving on to item number 12. This is an administrative item. Kaiser Marsden Associates will, thank you. Associates will present results of a study commissioned by the Santa Monica City Council, encompassed by their report, the Ellis Act and its effects on rent-stabilized housing in Santa Monica, a study of factors leading to withdrawal and possible mitigation strategies. So whenever you're ready, we're ready.
Good evening. I'm Kathy Head. I'm the managing principal of the Los Angeles office of Kaiser Marsden, and I'm here to present a summary of the analysis we did on the Ellis Act impacts on rent-controlled units. And it's kind of weird not being able to see the screen.
You can turn around if you want.
No, I'm not going to turn my back to you. I have a written copy. I'm good.
Honestly, you feel free to turn your back to us. It's fine. If that'll help.
Okay, just so I can have a sort of a visual.
Of course.
Okay. So our report was divided into several sections. To give you context, we started with some information about the various state and local laws that impact rent-controlled units and how they can be removed from the inventory. We did a literature review of studies that have been done on the Ellis Act impact on rental units. We looked at some other cities and the impact the Ellis Act has had on those cities. We looked at Santa Monica, and we looked at the impact of the Ellis Act, and we focused on that, obviously. And then we provided some recommendations for what you could do to mitigate the damage created to the rent-controlled inventory by the Ellis Act. I don't know how you normally do this. As a general rule, I'm pretty comfortable just answering questions as I go, but if you want me to run through the whole thing?
Why don't you, we're kind of free and easy too. Why don't you run through your report, and if we have questions and I see a hand raised, then we'll ask commissioners to ask you as you go.
Perfect.
Is that okay?
That works?
Very
okay. I'm just going to run through the legislation pretty quickly because I'm pretty sure you all mostly know about it. So clearly, the Ellis Act, being the first piece of legislation that we'd like to talk about, was enacted in 1985, and it defines the criteria under which units can be removed from the rent-controlled inventory. Then Costa-Hawkins comes into effect in 1995 and tells landlords that they can raise the rents to market rents every time a unit becomes vacant that was under a rent control situation. Then we have California density bonus law, which has been amended numerous times over this period of time. And the most important part of density bonus law for the purpose of this discussion was that in 2015, they added a provision to density bonus law that said if you're removing units, and again, it says a lot of things, but for the purposes of this, if you're removing units that were subject to rent control, you have to replace those units. And you have a couple options for how you replace them. You can either replace them, if the tenants are actually very low or low income, you have to replace them as very low or low income units. If they're above low income, you have two options as a developer. You can replace them as a low income unit at an affordable cost and put a covenant on it, or you can continue to treat it as a rent control unit. So the new unit has to be a rent control unit subject to the rent control rules. So developers have those options. Both of those provisions in density bonus law were designed to ameliorate some of the impact of losing affordable housing as a result of density bonus units, which the whole idea of density bonus was to create affordable units. On the right page. Okay. So then, from the city's standpoint, I'm going to guess you know all of these, but I'm just going to run through them quickly. Rent control was adopted after an initiative in 1979. In 1988, as part of the zoning code and general plan update, a condominium conversion ordinance was put into effect that limits the opportunities for converting to condominiums when vacancy rates are low in the city. There was TORCA, which was in place from 1984 to 1996, which allowed for conversions with tenants participating or tenants being allowed to stay in the units. The one thing that left over from TORCA, which expired, was the eviction clauses for those people. Proposition R, which is effectively inclusionary housing, was adopted in 1990. The home sharing ordinance, which we'll talk about more and as part of this presentation, was adopted in 2015. And then two programs that were done that don't really have anything to do with the Ellis Act, but do have something to do with how the city is showing their commitment to preserving affordable housing, were the House program and the POD program. Okay, so next, we have a fun-filled chart. So, what we wanted to show, and what is sort of a fundamental premise of our analysis after we did all our research, and it wasn't a surprising conclusion, to be honest, was that as property values are going up, Ellis activity goes up. As property values go down, or as the market stagnates, the Ellis applications go down. You know, amazingly enough, that bore out when we looked at a time trend of it. So, I mean, I think that the one takeaway from this is really tied largely to changes in the market economy for properties. I mean, that's the primary reason that people Ellis their property, is because property values went up and they perceive it to be a higher value for their investment to change the use. Sorry. We ran, just to provide some context, we took 3 properties that had actually been Ellised, and we ran some pro formas on them, just really conceptual, order of magnitude. We had the actual values of what they were purchased for and what they were sold for, but then we had to do our best professional guess as what the costs were to newly construct the project for then to sell. Because if you look at just the beginning price that they paid for when they bought it, and then what they were able to sell the resulting project for, you get profits ranging from 150% to 400%. Well, that wasn't really what happened. I mean, what really happened was they bought it, they spent a lot of money to build, and then they sold it. And so our best analysis that we, again, order of magnitude, really order of magnitude, was that they were generating from these 3 sample projects, which were, again, real projects, between about 34% and about 46% profit. And that's a really compelling amount of profit. If you figure from the apartment development that they had, even if they had a large number of market rate units in those rent-controlled units, so they had a lot of turnover, this is still probably 3 times the profit that they would have made from them as rentals. So again, this just goes to support the notion that sort of the primary reason developers or property owners Ellis their property is because the values are just so much higher. Okay, that's one major reason. Okay. So then, changing gears a little bit, we're looking for potential triggers of Ellis Act in addition to that. And so one interesting thing that comes up in the analysis and looking at the data is out of the plus or minus 27,000 rent-controlled units in the community, about 28% of them are occupied by pre-1999 tenants. So they've never turned over since Costa-Hawkins. So I think so that group of people, so more than a quarter of the tenants in rent-controlled apartment buildings, now again dispersed however they're dispersed, are still paying their 1978 rent as adjusted by your rent control adjustments over time. The rest of the units, the other 72% of the units, actually turn over pretty frequently. They turn over at a rate of less than 3 years. Now, what I will say is I think as rents continue to go up in Santa Monica, and as dramatically as they've been going up over the past several years, I think you'll see a trend built over time of fewer and fewer occupants moving out unless they're moving out of Santa Monica, because the opportunities to find rents that are affordable in Santa Monica are very difficult given the increases that have been experienced and the vacancy rates, the adjusted vacancy rates. But with the data we had, it's about 2.7 years. The increase in rent went on vacancies median increase is about $245, and it's about a 16% increase in rent. And if you look at the chart, you can see that the majority of the rent increases for this group, again, the 72%, is about $100, $0 to $100. And as we say, the median's $245.
Nicole's a question.
Oh, sorry. Thank you. Commissioner Phyllis had a question.
Sure. Sorry, a little different. So I think most of us are actually, if I could just give you a suggestion as to kind of how to tailor your remarks to the board. Most of us are familiar with kind of the background about what Ellis is. What we're really interested in, and I was the one who originated this item to council, so I feel like I have some ownership of it. But what we're really interested in are looking at the factors and the relationships that tend to drive Ellis activity. So I can give you an example. One was, you said, land use values, right? And as residential property specifically goes up, you also tend to see an increase in Ellis activity. I think that's what we're really concerned about here. So could you maybe kind of go to that point? And I know I have a lot of very, very specific questions with regard to your recommendations. So,
okay.
You know, if you
so you'd like me to speed it up?
Yeah, please.
Yeah. I have a question.
Okay. Before we go, there's I think a couple more questions.
Sure.
Go ahead.
I mean, I'm not trying to cut you off,
No, it's okay.
but you know, I do want to give you a little bit of direction. Most of us have been on this board at least 2 years, so we're pretty familiar with how the Ellis Act works. What we are concerned about is what drives Ellis activity, and that's really not, I think, what I'm hearing yet, except for this land use, or land value. Sorry, I keep saying land use. Land value.
I mean, I would contend that is really about 95% of it.
Okay. So maybe I can.
Wait, I have a question though.
Yeah.
Okay.
Because we are on the trigger slide. I just want to know exactly what the triggers are.
Aside from value, land value. I mean, is that the
I mean,
ultimate
it's primarily
conclusion?
land value. It is primarily property value. I mean, it's the fact that a property owner perceives that they'll make more money by either redeveloping it themselves or, more commonly, selling the property at a high increase in value and then having somebody else do it.
So I think like what I'm interested in knowing, and again, this is Nicole's item, is how we disincentivize that.
And and I actually do have a couple questions for you, because I think it's a little bit of a cop-out to say that it's just tied to land value, because land value is affected by a lot of things. And one of the things that was noticeably absent in the report, and which I was concerned about because it was kind of the impetus for this item to begin with, was, okay, how does zoning, upzoning and downzoning specifically affect land value? And I really don't see that here, and I'd like to know why.
Well, okay.
I'm Barbara Collins, and I'm the housing manager, and we actually were the ones that worked with Kaiser Marston to actually contract for the scope of work. So with all due respect to your board, I would suggest that you let Kathy continue through her presentation to have you hear the overall presentation. You're the first ones. The public has not heard it as well. And I understand you have specific questions that she'll be happy to answer, or we will at the end. But I'd like the public and you to hear the whole presentation of what she has done methodically through this process to get to the recommendations at the end. And staff is actually here today to hear what your comments and concerns are. We're going to the Housing Commission with this report next week, and we want to make sure that we hear all the different things that you think and or want. They may or may not be in the report. There were certainly economic factors to evaluate in terms of the cost and analysis of what we looked at in the report. So if there's specific recommendations you think need to be further fleshed out as part of the future of trying to get to that $1 million answer, we're here to hear that, and ultimately there will be some recommendations that go to council to do some work going forward on that. So I just don't want Kathy to take the hit for what's in the report. Hit us if there's things in the report that are not what you were hoping for.
Well, I can give a little bit more direction, because, I mean, to give some context, this recommendation came up because we were talking about Measure LV, and there were all these statements being thrown around about what upzoning or downzoning or a moratorium would do to land values, and whether it would inhibit Ellis activity or whether it would incentivize Ellis activity. And I do not understand for the life of me why these zoning elements are not addressed in this report. These zoning issues. Do you understand what I'm saying?
I do understand what you're saying, but I think what we've actually determined, and maybe those things specifically are not called out to the extent that you wanted them to be in the report. But I think the primary factors, and looking at the other jurisdictions that Kathy did as part of this analysis, or Kaiser Marston did as part of this analysis, is that overall those things are not the driving factor, as Kathy said. It's an economic factor, and that those were recommendations that council could consider or could be pursued in more depth if those are recommendations that you make that you think need to be included, or that the Housing Commission makes that they think need to be included. But I think we were trying to look at part of this as what to do to prevent this, or how to try to mitigate it in the future as the primary source of the issue.
But so what I'm just saying is I think that the level of detail in determining how do we assess land value, that's directly affected by zoning. If you can build a taller, bigger building, you're going to be able to get more for it. And what I was really concerned about in bringing this item was, what is the relationship between those zoning, look at it historically, those zoning changes and Ellis activity. So, that, it doesn't, I don't have to belabor the point, but that is something that, I would like to see more of going forward, and did really stand out, and I can have some much more
Why don't we just
specific.
let her finish, and then we can give the feedback?
Okay.
Okay.
And I would actually contend, with all due respect, that the information from Santa Monica and the information from the other cities indicates that the vast majority of these projects are actually downzoning or maintaining the amount of units. So it's not a density bonus play, which is why the density bonus play in the new rules that don't require replacement housing are not effectively curbing Ellis activity. Because if you look at West Hollywood, you look at Santa Monica, notably, and San Francisco, you'll see that the density of the new projects is either the same or less. Jumping ahead to a recommendation, just to answer your point, one of our recommendations was to say to have one-for-one replacement, so that you don't have fewer units on the site than when you started. So I think, in my opinion, my professional opinion, I did answer that question. You can disagree, and that's...
No, I do disagree, and I can give more specific. There's not a zoning analysis in here, and it doesn't stop at a density bonus.
Okay, well, I do feel I have to respond. The fact is, people aren't asking for more density. So what zoning would you want me to be looking at?
So I would like you to look at historical zoning changes over time, right? Because zoning has changed over time, and look at whether these buildings are being replaced with higher density or lower density buildings, and whether Ellis activity has actually increased following zoning changes going down or up.
Okay, and again, I'm going to say the same thing I said, and then I'll move on, is people are replacing with fewer units than are on the site. They're not replacing with more units than were on the site.
Okay.
Okay, so maybe if you could go ahead and go through your report, and then we can just hold our questions till after that.
Okie doke.
That will have all the information in front of us. Thank
Okay.
you.
Okay, so Ellis acts were most common in 90403, 90405. And again, as I've mentioned, it's small projects as a general rule. Very few projects over 20 units have been Ellised. In the 3 zip codes with the most, it was 4 to 6, and then in 90401, the average was 12 in the amount of units. Oh, I'm in the wrong place. Okay. So the next thing we looked at was how long people had owned their properties when they Ellised. And the reason we looked at that was because one of our theories was that the vast majority of Ellising is happening by property owners who have recently bought the property. So in other words, property owners sell their property with the intention of Ellising it. And if you look at that, you'll see that 73% of the units that were purchased within a year were Ellised within that year. And 25% had been owned for more than 10 years. Okay, so then the disposition of Ellis Act properties, which I think plays into the general questions about what's happening with these properties or why property owners are using the Ellis Act, is condominiums are making up about a third of the uses, and then single-family units are really the next highest. And so again, what's happening is small condominium projects are replacing small rental projects. Single-family units are replacing small rental projects. That's the vast majority of what's happening with the Ellis Act. And it's effectively the same on the reuse. What page is that? 9? Yeah. So instead of new construction on the reuse, you have sort of a similar concept. Single units are very prevalent. Owner-occupied single units become on the reuse, become a more prevalent. Okay. So then we had the trend of what had happened with the reuse of properties over time from 1986, when the Ellis Act went into effect, through 2016. And again, over that whole period of time, condominium reuse was the most common and commercial was the second most. And then from 2010 to 2016, family occupancy, single unit dwellings. And again, and this is true not only in Santa Monica, this single unit dwelling conversion of Ellis Act is very, very common. So either for family occupancy or for resale. So again, it's a downzoning.
Sorry, you probably have it in here. I just wasn't clear after looking at the charts what percentage of those that are being Ellised are being converted to single family.
It was 24% on the reuse, and it was a similar percentage on, I have it in the report.
Okay, so, sorry, I guess I just don't know where exactly.
Yeah, it's not, if you look in the report, it's in the report, in the full report. Does anybody have the full report out?
We have it.
Yeah.
Yeah, that's fine. So you're saying 24%?
Plus 23, 24%.
Okay. Of everything that Ellised,
yeah.
Over what time period? From 2015 to
2010
17?
to 2010 to 2016.
Okay, so that was for single family.
Right.
Thanks.
Sure. Okay, so the other question that was asked as part of this assignment was to look at what short-term rentals, what impact they've had. Now, there's limited data available in the city on the short-term rentals that are actually the inventory of short-term rentals. And so the best information the planning department could give us, and the reason if you read in the report the alleged short-term rentals, is that was a requirement that the planning department got from their information source as to how this could be dealt with, because these are not necessarily verified and they're estimates of the short-term rentals. Given that fact, though, I think the data shows the dispersal of the short-term rentals. And again, they're most prevalent in 90403 and 90405. And the reason short-term rentals are interesting to this question is because of the fact that they are considered to be a more profitable use in your high-income, high-rent areas than apartment rentals. And so you see developers, again, not just in Santa Monica, you see it in Venice, you see it in Malibu, you see it in downtown LA, you see it in Hollywood, where property owners will, through means available to them one way or the other, take rent-controlled units and attempt to use them as short-term rentals rather than rental units. But again, and I will say this, there is really very limited data in Santa Monica for the actual inventory of short-term rentals. And so we did the best we could with that.
I have a question about that.
Okay, go ahead, quickly.
So thank you for this report. We appreciate you being here. But I've got to echo a bit of what Commissioner Phyllis was starting to say, in that I'm finding some holes in where I want to see some meat. But when it comes to your definition of short-term rentals and the implication that perhaps there's not enough data in Santa Monica, your report on page 5 defined our goals as, Santa Monica's stated goals as being preserving rental housing. And on page 11 of your report, you said that short-term rentals in our region, and you specified the beach, Hollywood, and that would include us.
Right.
That short-term rentals reduce and distort the housing supply and prompt tenant displacement, and that, for instance, in LA, they cost them up to 11 units of housing a day. Yet on page 33, you're encouraging us to engage in whole apartment, in rent-controlled housing. I don't understand why you would say that there's not enough data in Santa Monica to say something that I think that your own report, I think, clearly shows that it's an extremely damaging element in our housing picture here. So damaging, in fact, that there was enough clear evidence for the City Council to enact a very strict, first in the nation, strictest short-term rental regulation.
Right.
So I don't understand how it could be reached in a report that there's not enough data for Santa Monica, or that one of your recommendations is to allow it. So if you could address that.
Sure. My data point was to say I can't tell you what that effect is. I can't tell you the LA number. LA did their own study where they had the number of what that impact was per day. I don't have that level of information.
I don't think, but I wouldn't think a specific number is required to reach this reasonable conclusion, or an unreasonable conclusion that renting whole apartments and rent-controlled housing in exchange for something that's in a different, an entirely different category of housing doesn't seem to be in keeping with our goals as you helped define them on page 5 of your report.
No, I understand that. I understand what you're saying, and I don't disagree with what you're saying. I'm just saying I can't quantify it. I think in the recommendations, we said that you could look at these ideas that have been used by other cities. You could say, no, I don't want to do that. And you can absolutely say that. But this was just ideas being offered.
I know. Okay. Everybody's chomping at the bit here. Everybody really wants to ask a lot of questions, and I want to be able to have you finish your report so that we're all operating on the same page. There are some direct questions regarding this particular issue. Yeah. So, commissioners, if you can stick to this particular issue, then we can ask her the questions.
This is very specific to short-term rentals. So, recommendation 7, you recommend we consider allowing home sharing platforms such as Airbnb or VRBO to list whole homes, which I'm assuming you mean whole apartments.
Whole homes and whole apartments.
Single-family homes. Okay.
Yeah.
So what about
whole
dwellings in B? Does that include apartments?
No, it's right now the way your ordinance is written, exactly as you mentioned, was you can only do a short-term rental if you're home.
Yeah.
Right. So this is just a recommendation to say if you wanted to, and again, I don't have a horse in this race.
Yeah.
You know.
I want to say.
Wait a minute. Let her finish. Go ahead.
Okay, is to say that one tool that you might have for promoting affordable housing was to loosen up on the vacation rental in return for getting affordable housing.
So you would, I just want to make sure I'm understanding the mechanics of this proposal. You would say in a 30-unit building, okay, landlord, we'll let you do 2 units of VRBO if you will keep the other affordable. Is that the proposal?
Yeah, in essence, yes.
Okay, so my question is for you. Do you understand that under the rent control law, we have something called maximum allowable rent?
I do.
And do you understand that allowing some of these units to come onto the market as short-term rentals would likely exceed the maximum allowable rent allowed for landlords or anyone to collect on that unit per month?
Yes, I do.
So why did you make that recommendation?
I will tell you honestly, I was asked to make that recommendation.
By who?
By city staff.
Can I make,
okay,
before we continue, hold on.
That's interesting.
But again, and now let me own it, because I wouldn't have written it, nobody actually made me write anything in this report, here's a series of recommendations. Now, reasoned minds can say exactly what you just said and say, no, we would never do that.
We can't by our charter.
Okay, you can change your charter if you wanted.
Well, we'd have to do it by a ballot initiative.
Okay, all I'm saying is then you can say, for a variety of reasons, and after, as Barbara said, after this meeting, we can change the report for, a reason like that.
Okay, I have a question for Commissioner
Yeah,
Teresa.
no, I just want to say, like, so we can stop continuing down these paths. I mean, I don't think anything that Kathy is proposing here is so ridiculous. I actually think it was really incumbent upon city staff directing the work of Kathy and her team to kind of, first of all, we know as a policy matter that city council has banned short-term rentals. So, I mean, I'm pretty disappointed that, city staff who should be familiar with what our policy objectives are would allow like a finalized draft of this to come to the rent control board. So I'm not, I mean, nothing.
Well, no, but I'm going to own it. Seriously, I could have said no.
Right. No, I know. But I mean, I think, you, as someone who came to present something to us, you did all of the background research, you presented practices from other jurisdictions, looked at our empirical evidence, and then presented options. And I think that hopefully this was a directed effort in concert with city staff, and I'm just a little disappointed at the direction that this took. So, I mean, I
don't...
Well,
blame me.
No.
Seriously.
No.
It's my report.
No.
Yes, I insist that you blame me.
No. I mean, I just don't want you to... Like, we appreciate that you came here and that you did this, and I don't want you to feel like we're personally attacking you, because that's absolutely not what this is. And it's all learning experience. So, anyway.
No, and I think just as a general context question, I mean, I think that one thing that's, because we struggled with this report. I'm going to be completely honest. We struggled with this report. It's part of the reason you're seeing it so much later, is the answers you want in several cases, and I suspect later in your detailed questions, don't exist. And we did the best professional job we can do on this job. We did, and we spent a lot of time on it. And we wrote it and rewrote it, and we gathered more information. And I'm really sorry if you're disappointed in it. And there's really not a lot I can do about that, to be honest, because this is our best professional job. And if it's not acceptable to you, then I'm sorry.
No, listen, not what I'm saying.
Well,
okay.
That's kind of what's being said. But anyway, moving on.
Yes, if you'd like to, go ahead and finish the report.
Yes.
If we can hold comments until the end so we can get through the report.
There's only 5 more slides.
Okay.
Okay. So what we did is we pulled the mitigation policies in other cities to give you an idea of what other cities who are struggling with exactly this issue have been doing. And so in LA, they've taken the stance, and this stance is, I think, still up to interpretation by their legal staff, that rent-controlled dwellings that are lost have to be replaced with an equal number of affordable units, which would be true in a density bonus situation, or 20% of the new rental units, whichever is greater. That's an aggressive stance. That's definitely an aggressive stance, but it's in their policy. Berkeley established an impact fee for each dwelling unit that's demolished in a structure that was built prior to 1980 when their ordinance went into effect, or asked for a replacement on 1-for-1. They also are prohibiting demolition for 5 years after an Ellis Act. East Palo Alto did a 1-for-1 replacement. So if you take out a unit that was rent controlled, then you have to replace a unit. You can't, so in other words, you can't take out a 6-unit building and replace it with 4. Okay. And again, let me re-mention that because the vast number of these are actually either staying at exactly the same number of units or reducing the number of units, as opposed to increasing them. West Hollywood has a draft ordinance that does the same thing, that's looking at the 1-for-1 replacement. San Francisco, what they've done, and San Francisco has really been the most active city in this whole issue, in the Ellis Act issue. They've done a lot of studies over a number of years. We talked to them for countless hours, and we read everything they've written about what they've done. And so what they do is they keep a list of the buyouts that have been paid to tenants to ask them to move. They also have contracted with a nonprofit to look for small buildings that are at risk of being Ellis'd and trying to buy them. They have a money source to do that. And then they resell those for market rate or for workforce. And that's their small sites program. They also do legal support, but so do you, so I'm not going to go over that. Which brings me to recommendations. One thing that San Francisco has actually pursued legislation at the state several times, and they've been unsuccessful with their efforts. I think to the extent that like-minded cities like Santa Monica, Berkeley, West Hollywood, San Francisco, Oakland can get together on that, and you know, just like AB 1505 that basically just came out of Santa Monica, I mean, this stuff can be done if you guys can all get together and get the legislature behind it. I think the other one that's really key is enacting replacement housing requirements. So the one-for-one, I think, is a really good concept because, again, you don't want 4-unit projects being replaced by one single-family home. You can look at, I mean, with what financial resources are left after the elimination of redevelopment, you can look at the purchase of small buildings that are at risk of being LS'd. The other thing is the demolition restrictions, and again, we recommend that be discussed with legal counsel because imposing the demolition restriction, while it is being done and it's being explored, it's definitely, it's beyond my pay grade to decide whether it's legal. Another thing that Berkeley's done and is being considered in other cities is the imposition of an impact fee for units that are being LS'd. And Santa Cruz is actually looking at this concept now for their inclusionary program too. So not just in cities with rent control, but so the imposition of impact fee would be something interesting to look at. The other one is to look at restrictions, more restrictions, because you have restrictions, but more restrictions on owner and family move-in. And I'm not going to talk about short-term rentals now, so I'm done.
Okay, I know that Commissioner Flora has been very patiently waiting, so you can have the floor first.
Yes, thank you. Would it be helpful with regard to the recommendations? I was kind of trying to race to write down which city kind of each one of these applied to. So I assume that each one of these recommendations on pages 32 and 33 have either been tried somewhere or are enacted somewhere. Are these sort of a best practices of things that have been put into place?
Well, except for the short-term rental.
Okay, forgetting the short-term rental punching bag, I think you all know how we feel about that.
I think I got it.
Yeah, it was a little startling. I'll add to the chorus on that. As you modify the report, it'd be great to just parenthetically put where something is, or where something is being considered, or where something was tried and failed. I mean, tell me where these things are happening, or are these just concepts that
No, they are elsewhere in the report, but I understand your point of then just sort of having them right there in one place. No, I think
I recognize a couple of them from other places in the report, but just having them here, so it tells me on this 2 pages,
right,
I can point to, hey, East Palo Alto did this, so I know we can do this. You know, that kind of thing.
Sure.
Because some of these sound like they just might have been conceptualized.
No, they were really.
For example, has anyone put a cap on the number of rent control demolitions?
Yeah, Berkeley.
Berkeley?
Yeah.
And is there any evidence on that it inspired a rush to Ellis? Got to get to Ellis before the cap, or is it working?
No, I think it's not. It didn't. There isn't. In Berkeley, they've actually pretty much controlled their Ellising to the extent that they can.
Mm-hmm. So that's working.
I think the combination of what Berkeley does towards their Ellising has so far been successful.
Okay. Thank you. I'll let other commissioners move forward.
I have Commissioner Foster on cue next.
Thank you. So I really think it's an interesting concept to follow the path of an impact fee and to decide how we might contribute those funds to either the POD program or something similar for rental assistance or retention of current tenancies. I think that's a great idea. One of the things I found most compelling, and I was doing screenshots instead of notes last night, but on one page, I don't know which city it was, incentivizing landlords to reinvest in aging properties instead of withdrawing them. And then also you mentioned cities that are purchasing at-risk buildings. So one of the things I both of those sound great to me. Helping landlords who do want to stay in, keep going, and also potentially purchasing buildings. We do have some potentially a source of money for that now, again, in GS and GSH, but what I don't see in the report are any ways, some of the, when I made reference to meet or things I'd like to see in the report, I don't see what identifies them. All I see is high property values, high Ellis, low property values, low Ellis. I mean, that's pretty much the gist of the entire report. What I don't see is one of your recommendations is purchasing at-risk buildings or identifying and encouraging landlords, but nothing says how you identify it before it happens. So I don't think I heard or read anything about identifying landlords that need help fixing it up or identifying buildings that are at risk to purchase them. So I don't see how to get there from this report.
Okay, that's fair.
Okay. I mean, is there anything in your anecdotal evidence that's not in the report?
San Francisco. I mean, the San Francisco program. We have pages and pages of information on the San Francisco program.
Is that something you can share at another amended version or another date?
I'm gonna talk to these guys about that. We have it. I mean, we have it available.
Okay, I just think that is an example of something that I think we would find very helpful to the discussion of Ellis.
Okay.
Because I think what Commissioner Phillips was trying to say is that we do fully realize that speculative real estate is the reason we're all sitting up here. That's the reason the law was enacted in the first place, was speculative real estate and the harm that it can do to the fabric of a community. So we're aware of the pricing issues. I think what we're looking for is good examples and substantive ideas of what we can do to identify the buildings at risk.
Right.
That's kind of the whole thing.
No, and I think on a micro level, I think that's a really good point. I think on a more macro level, I think the issue was what our intention was and what we did was we went through all the cities that have active activities to ameliorate their Ellis problem. And we said, here, look, here's what they're doing. I mean, because you're right. I mean, I believe that the cause is property values.
Sure.
Okay. So, yes. When Andy first told me about this study, I said, well, the cause is property values. So I agree with you. That's
right. But we look to save in whatever form is tenable for the landlord and the tenant every unit possible.
Understood.
So identifying the factors that make something at risk and identifying it before it's too late would be something very, very relevant to this.
Yeah,
study.
and I mean, and I think that, well, okay, two things. One is just from the data in Santa Monica, we know which properties have Ellis, right? We know that. And we have, and I mean this literally, we have 56,000 pieces of data for these properties. Okay, and so we know which properties were Ellis, but what we don't know was what the market rent was. Well, I mean, it could be figured out.
We do.
No, I understand. No, you
know what the
do,
market
but you
rents
do,
are.
but you have it within 56,000 pieces of data. And so, at least from our capabilities with 56,000 pieces of data, using 100 Main Street as an example. You have 100 Main Street, units 1, 2, 3, 4. Okay. Those 4 units can show up 100 times. They can show up 10 times. They can show up an unknown number of times. What we need to figure out, to figure out these issues about what the varying rents were at the beginning and at the end, was we need to, so if we just did it for 100 Main Street, we could do it. We could find 100 Main Street. We could do a data sort, and we could find 100 Main Street. But to do it with every single project that has been Ellis, or is at risk of being Ellis, we're looking at 27,000 units and 55,000 pieces of data, many of them repeating because people move in and out and move in and out. We don't have...
And I'm going to just interrupt you just for 1 second. So I think one of the breakdowns in this process, and I think Nicole Phillips could have something to say about this, is that her request she was the originator of the request for the report. This body and this agency, we are experts in all the things you're presenting to us on, so it's actually kind of, other agencies might benefit a little more from a cursory examination of property values, but I think our own staff report, our own annual report probably has more data already derived from those 56,000 data points that you gave an example
And
of.
we use them. And we used, in fact, we used the last several annual reports to do that. But again, it's a question of, or at least a question that was posed to me, you didn't pose it to me, was that for each building that's been LS'd, what was the rent for the units when the people moved in? What was the rent when they moved out at the time of the LS? And what was the market rent at that time? Okay, so
And are you trying, I'm just trying to understand, are you drawing a line between that and defining it as at risk before it goes? Is that where you're going with this?
No, I was just trying, this was sort of the meat question, was what would be great to be able to do, and I mentioned this, and I've mentioned this around, is that we have the information. Let's just say that we can work the logistics of the 55,000 pieces of data. We know what rent was being paid by each tenant. Okay, so we've been able to do the sort. We know what rent they were paying when it LS'd. But we don't know what the market rent was when it was LS'd. So we don't, so say a 2007 LS.
I guess I don't understand why you didn't know, because all of the rents are registered.
But they're not market rents. So the tenants lived there for 4 years. So, right? The market rent's gone up, but their rent's gone up by your adjustment.
I'm not understanding
Okay,
what data point
let's take a really obvious example. A pre-99 tenant is paying a 1978 rent that's been adjusted each year.
Sure.
Okay, the difference between the rent that tenant is paying and the now current market rent that would be
And are you defining current market rent as maybe a recent move-in?
Yeah.
Or are you talking about a non-rent controlled building?
No. I'm talking about, because again, it's only relevant
But
if
we
it's that
know
actual
all
building.
within 30 days of them moving in, up till 30 days ago, we know what those exact...
You know what they were paying, but you don't know what it would have rented for if they had vacated.
Oh, what it would have rented for if they vacated.
See what I'm saying?
Sorry, okay, I don't think you stated that exactly.
I didn't.
Okay.
No, I didn't.
Okay.
No, so thank you for allowing me to clarify.
Sorry,
because
it
I
took
knew
a little
I knew I wasn't getting there.
Find what, okay.
Well, because market rent, I think, became the issue. But okay, so an unrestricted rent, a vacancy decontrolled rent.
Sure.
So what the gist would be say, hey, is this building at risk? Because these guys are all paying 30% less than the unrestricted market rent, or the vacancy rent, the vacancy decontrolled.
But I would think you could have, and I'm not sure how big of a team or how many data points you're able to process. I think that's why we assign reports and analyses to big companies, is so that they can handle whatever number of pieces of data. I don't find that to be compelling. We use, in our very report tonight, our staff used comparables to arrive at what a fair tenant not in occupancy new rent would be. So for you to say that you don't know and weren't able to extrapolate data on an unknown thing like a current vacancy, I think that there are comparables. My dad was a real estate broker for 40 years. There are comparables that you can go out and look at. So even if you don't know what the person living there might have paid if they had moved out and the next person would have paid, in the building right next door, there's somebody who just moved in. So,
but but then as a practical matter, yes, this can be done if you have an unlimited budget.
What was the budget on this project?
It was $38,000.
That's all that was allocated by city council?
No, they allocated more.
How much?
I think they allocated 60.
All right.
No, but I mean, and again, but believe me though, the fact is, again, what you're saying is all conceptually possible, but then you'd have to go out, someone would have to go out and get comps for each one of these Ellis properties.
Well,
and again,
that can be done.
No, it can't, because you'd have to look at 2008 or 2012 or 2015, whenever the building was Ellis. You're not looking at it today, you're looking at when it was Ellis. So not, yes, you could do it for a sample of 2016 buildings.
Okay, and I do understand your point. I think when this body asked this report to be done and city council then sent out an RFP for this report to be done, I think we were hoping for more.
No, I understand.
Is what we're trying to say.
I understand, and believe me, I would like to be able to give you more, because I would like this to be a report that was useful. I mean, that's my primary objective. But again, and it's not just, I think you're misinterpreting, or I'm miscommunicating the 55,000 pieces of data. It's not because there's 55,000 pieces of data. It's because they're not unique pieces of data.
It's okay. I don't want to belabor the point.
Okay.
I wanted to know, in your recommendations, you kept talking about buying at-risk buildings or identifying at-risk buildings, and I thought that went to the very heart of what we were hoping to achieve in this report, and it was identifying risk factors and identifying at-risk buildings. And I'm
Okay, I've got two people talking to me at once.
well.
Now
I'm not seeing the data that satisfies the original request, which was data to identify buildings that are at risk. And that is included in one of your recommendations, yet there is no supportive data to, so maybe the bringing forward of the report was premature or something, because the actual request was for identifying risk factors. That was in the language of the request.
And I think the risk factors are, and I think that's a legitimate point, is that it's the small buildings. It's the small buildings, the 4 units and less buildings that are under rent control, and those are the units you should be looking at.
That was in the report.
Yeah, that was. I've had my question answered. Thank you so much.
Thank you. Moving on, Commissioner Phyllis. Or is there a comment from staff?
My name is Elsa Brown. I work with the Housing Division. And so there was a few characteristics that Kathy mentioned in her report that could be used towards identifying properties that could be potentially at risk. So some of the things that she mentioned was that properties are owned, have a new owner that have owned the property for less than 1 year, have a high probability of becoming Ellis. So that's something that we can look at. She also talked about there's 2 zip codes that have a high probability of being Ellis, because there is a lot of Ellises in those zip codes. So we can look at those zip codes. There's properties that have 4 units or less are also a high risk of being Ellis. Because that's what we've been seeing. So those are all things that we can use towards identifying those properties. Also, our staff has been looking at strategies on how to identify properties that are at risk of losing their affordability covenants, and she does talk about that there, so that we can assist, we can see what we can do to assist the owners of the properties to extend those affordability covenants, whether it be through offering them, working with them to maybe use our housing trust fund funds to extend, to maybe do some renovations on their properties,
Can I ask
right?
a question about that?
So
But that specific point.
these are some things I think that are addressing some of the comments that you guys had as far as identifying properties and what the city is doing to assist property owners who want to stay in the business.
Thank you.
Wait,
Okay.
sorry. So we're talking about rent control, not affordability covenants, correct?
Right, but somebody had made a comment earlier about that, so I mentioned that.
I think she was talking about
Yeah, I was talking about the
preserving rent
short-term rentals
right.
recommendation was that
Okay.
you were trading our already protected
Yeah.
affordable units
Okay.
for
I don't think we're
something
talking
that's
about
not for something
project-based
that's not in the
Section
same
8.
realm.
Okay, so then I think just
Unless
you
you're
can just
talking
take
about low income or low interest financing for owners or something, that's a different story.
Okay,
Okay.
so then you can just take, like I said, you guys were talking about some characteristics that we could use to identify Ellis apartments that were, or Ellis properties that were at risk, and those what I mentioned earlier, which was in Kathy's report, is some of the things that we can use to identify those properties.
Great, thank you. Commissioner Phyllis, you have the floor.
Thank you, Commissioner Drawn. So I want to give some more specific feedback with regard to your recommendations. I think you indicated, and you may have alluded to it, but not specifically said it, that some of these recommendations you have not really investigated the legality of them. And it seems like, and I'm also a lawyer, so maybe I'm looking at this with a legal eye, right? But it seems like I would have some concern about Ellis preemption and
Ellis what, I'm sorry?
So being preempted, local ordinances being preempted by state law, right? And it seems like that when you said this is above my pay grade, it seemed like that was maybe what you were driving toward, specifically with regard to the impact fee and potentially with some other local measures which could be used to technically inhibit or punish Ellis activity. So my question was, have you gotten any legal advice on these specific recommendations, and if not, why?
Well, A, we don't have a legal team member.
Okay, but
And so B, well, A, I'm not a lawyer.
Okay.
B, we don't have a legal team member. C, we only put things in here that other cities have done, presumably with legal counsel. I just, as somebody who's been doing affordable housing for 35 years and only play a lawyer on TV, some of these things I look at and I say, wow, that doesn't pass a sniff test for me. But it passed the sniff test for legal counsel in, important, powerful cities that have good legal counsel. So that's why I told you about them, but I also told you that I would definitely ask my own legal counsel before I did anything of these recommendations.
I mean, I understand that, and I also understand, and this is really directed towards staff, I understand that this was a limited budget. Quite honestly, I was shocked that it was $38,000. I remember speaking with Councilmember McEwen when I came and asked for the item, and it was definitely in a six-figure range, I think what I had envisioned. He asked me how much I thought it would cost, and I think I gave a six-figure range. It was definitely higher than 38,000. So maybe I think lowest. She said the budget was 60. They didn't spend it. Yeah. So I'm just a little bit concerned about why the budget was maintained at such a limited fee, and I'm concerned about what appears to be some limitations on technical ability with regard to data sorting, and I'm concerned that this was done on like a very low budge scale, and I don't understand why, because this is really important and it's been something that we've been waiting for a long time. So I understand that's not your call, but please hear me, city staff, and I'm going to come and speak at city council and say the exact same thing. This is concerning. We need more money. If that's what we need, this affects enough units that if they're telling you they need more money to do the type of work that they need to do, then, I'm going to get up there and say, please allocate money to do this because it's important.
Okay, so just to answer a couple things and to take staff off the hook for some of this. When I read the scope, I made a proposal for the scope that was, I think, not as specific as the scope that you're looking for. And so it was my proposal. So it was my proposal and my scope. I think the scope you're asking for is dramatic, and probably in your mind, definitely, and maybe on paper, was more. But when I was working on the proposal originally, I was given the impression that it had been originally thought of as a much bigger project, like hundreds of thousands of dollar project. And then it had been scaled back. And then, honestly, then I scaled it back further, again, with the premise that, here's the answer, and here's what other folks are doing, and this is what I think I can do that for. I am going to have to say we have the technical ability to do the sorting. So that wasn't my point. My point was it's an expensive proposition. And so then I think that collectively, your board and the city and the rest of the stakeholders in this matter need to evaluate whether they want to spend that kind of money to get that information.
So how expensive, and then I have two very discrete follow-up points that I want to also hit, but how expensive?
And again, all right, so I'm thinking out loud. So what we'd have to be able to do, we'd have to be able to sort to figure out what the last tenant was, when they'd started, when they'd finished. Okay, so that I think is a reasonably doable proposition. Then what we have to be able to do then is either for a sample of buildings or for all the buildings makes a big difference. I'll finish my thought. So if we did it for all the buildings, then you'd have to get, at each point of time, you'd have to figure out through some mechanism what the unrestricted market rents were, to then compare what the rents actually being paid under rent control versus if they had vacancy decontrolled. So what was the landlord effectively using? If you were looking at 2016, even 2015, that again would be a relatively reasonable premise. As you get further and further into it, we have data sources that go all the way back to 1986, which is how we did the property value increases. What I worry about is comparability, because a one-bedroom unit is not a one-bedroom unit, is not a one-bedroom unit. And so locationally, again, you could solve for location. So you could get comparability by location. then you'd have to also be able to work to age of the building and the quality of the building. And again, if you were in 16 or 15, that'd be reasonably doable. You start getting into 2003.
So we're talking about tens of thousands of dollars?
We're talking about tens of thousands.
thousands.
We're talking about tens of thousands of dollars.
Okay, so I mean, that seems to me like a reasonable investment. So just, staff, I'm gonna come back to City Council and say it. So I have a couple other points. Item number 6, you're talking about owner occupancy evictions. As I understand it, and maybe our staff can correct me if I'm wrong, but that's conceptually distinct from the Ellis Act. So why is that in this report?
Oh, because other cities have done it as an Ellis Act mitigation.
Owner occupancy evictions, which I think they're different from the Ellis Act. Ellis is limited to when landlords want to go out of the business. So it just seems to me like a red herring. It's not really Ellis.
Right, well, except for some are Ellising to then move in. I think and that may be where this got lost in the recommendation. We have a section in the report about the owner occupants who they've Ellised to then.
But you don't have to Ellis to move in. You that, like, it doesn't make sense.
But then they convert. They make it another use.
Okay, it doesn't quite make sense to me, but maybe I'm missing something, and my apologies, but if you could clarify that connection, that would be really helpful to me, because we have a law in Santa Monica that allows owners to come in and evict tenants for an owner occupancy, no fault eviction.
Right.
So, and that's separate and distinct from the Ellis Act, which allows you to go out of the rental business entirely and is not tied at all to ownership status.
No,
so,
I understand what you're saying.
this seems very specific to owner occupancy evictions, which are not the same. So I was just confused as to why they're, and maybe others, but in Santa Monica they are distinct.
I understand what you're saying.
So my last point was, and maybe you can use downtown Santa Monica as sort of a case study, because I think this is where you've seen the most upzoning and then drastic Ellis activity. Because, and I know for a fact because I came and talked about the downtown community plan, and in Santa Monica, in the downtown, we used to have a lot more rent-controlled units, and there was a lot of Ellis activity, I think, prior to the 2000s. And then there were actually buildings that were rebuilt and re-rented within 5 years of occupancy, which resulted in these units becoming re-rent controlled, right? Because if you're within 5 years, then you're re-controlled. If there's a certificate of occupancy that reissues within 5 years. So, you're seeing, at least this is what happened in downtown Santa Monica, you're seeing these, 4 to 6 unit buildings get totally demolished. And when the certificate of occupancy was reissued within 5 years, now you have 5 or 6 original rent-controlled units. We have a ordinance in Santa Monica that says if you rebuild, all of those units are rent-controlled.
I understand.
Regardless of the original number of units that were there. So, which in actuality had a net impact of, am I mischaracterizing it? I mean, I know when we Ellised buildings in downtown Santa Monica, there were new buildings or more than 50% renovation, because I lived in one, that were substantially reconstructed, more units were on the property, and then you ended up having, I believe, more units returned under rent control than you originally had.
Is your point that they did it within the 5 years?
My point is they did it within the 5 years, but there did seem to be a lot of Ellis activity because you could build over low density 1 or 2 story buildings with 6 or 7 story buildings. And as we are considering increasing density and increasing height in certain areas of the city, I would like to know whether when we enacted those zoning changes, whether you saw an uptick of Ellis activity. And of course that's going to depend on the number of units that were originally there. But I'm concerned about that.
No, I understand that you're concerned about that, and I'm doing it from memory, so I don't want to do that. But it is my distinct recollection that even looking back at the data, that the units were typically replaced with they didn't upzone. But I don't want to say that. I mean, I'll absolutely go back and recheck that. I've got all that data.
And it may be different for different areas, right? Like if you're in primarily the north of Montana neighborhood, of course,
Well, no, yeah.
you're going to see, you know,
Well,
primarily.
none. You're going to see none.
Well, or you'll
effectively
see
none.
conversion to single family. Even in Wilmot, right? You're
Right.
seeing a lot of conversions to single family homes, or to condos, right? For a variety of reasons. But that's really, you know, something that piqued my interest and is interesting to me. And, you know, I would like to see if you can correlate the type of post-Ellis use to zoning, because, you know, I also was really disturbed by the number of commercial uses.
Right.
You know, we aren't really talking about that. Yeah, and I'm confused. You know, it seems like a lot of those.
downtown. I mean, some of it's downtown.
And so that again comes into this, like, how are we zoning things? Why are they going commercial? Which is, you know, again, I would really like to see more analysis of that interrelationship. And I'm ready to turn it over. And I really apologize if my tone came off
It's
harsh.
fine. I'm a big girl. It's fine.
I care so much about this, and, you know, there are people who lose their homes, and there are people who become homeless because of Ellis activity, and it's really, really important. And I know you know that too.
No, I don't. Believe me, 35-year affordable housing practice. I manage an affordable housing practice, so.
Okay.
It's not my first rodeo. No, I'll definitely relook at it. It's just, it did not come out, but I have all that data.
Okay, it would be great.
And I'll
to
focus
include it.
downtown because that is the most likely place.
Yeah, I mean, I think that's where we've seen a lot of changes.
Right. So so I think the notion is, so yes, it was a small building that was taken out, but were there examples of the intensification?
Thank you.
We'll relook at that.
Thank you, Commissioner Phyllis. Commissioner Trosis has some.
Thanks. I mean, I have some feedback, but just piggybacking off of Nicole's point, I would echo. I think that I was a little bit disturbed to see that there was a high, and I think if we're looking at page 20 here, I know we're talking about, like, primarily conversion of these small units to single family, and I know that that's what you said. You saw a lot of use after withdrawal, and then you know, conversion to single family, but I think we do see a high number of commercial and other uses. And again, to this point about zoning, I think, you know, I've been hearing about this Ellis study since before I was on the rent control board, quite honestly. City council was telling me about it, and my fellow commissioners were telling me about it, and everyone's so excited about it, and I think there was a lot of emphasis put on it. So I think that's why you're hearing all of this come out. So in any event, I think it was sold as, you know, we're going to look at how we disincentivize Ellis activity as it pertains to zoning, and what is the current zoning in areas that have a high Ellis activity. You know, is there anything that we could do around these areas to potentially disincentivize that from, like, a zoning perspective? Obviously, preemption is an issue, and we know that. And I think this analysis, I mean, to say that there's no attorney, I mean, I get that, but then I think we needed to, like, subcontract with one or talk to our city attorney, because I think a lot of these recommendations are directly tied to their legality and their legality under this specific city's ordinance, because it's different city to city. And I think that, you know, this is a highly looked at issue right now from a state perspective, and I just think that we needed to have some sort of legal counsel on this report.
Well, I will tell you, just to interrupt, I mean, I would tell you, I always just assumed, I mean, every project, I mean, I've worked in Santa Monica for most of my career.
Yeah.
And every project I've ever worked on, the city's legal counsel has always been taking the next step with it.
Okay.
So
yeah,
we would never presume, honestly, to come in with another lawyer and say, here's what you should do, because you have excellent legal counsel who, believe me, I worked on the loose for several years.
No, sure,
I
sure.
mean,
I just think I would have, and again, I really don't want this to be directed.
No, I get it.
At you. I think, like, I would hopefully in the future we can see, like, a better collaboration between city attorney staff and this report, because I think you really need strong legal counsel for some of these recommendations.
And that was actually the point I was trying to make.
Yeah, right. Yeah, absolutely. I hear you. I think that this, to us, reads a little bit like a digest of, like, these are the housing laws and then these are the best practices. And I think maybe for, like, a lay person, that's fine. But I think, again, you know, recommendations for the future, really, I think I would like to see a focus on the recommendation section and how we implement those, or potential, a little more detail around the recommendations as to how they could potentially be implemented in Santa Monica. And I understand that we had a limited budget, and that the whole amount allocated wasn't spent, but I think that would have been the most interesting to me. A quick rundown of best practices, and then this is how you can implement these best practices in Santa Monica. And then, of course, more analysis of what's going on in these commercial areas. I think those are like the main missing points for me. I assume you guys use like GIS technology to overlay. Okay. I don't know if like there are any recommendations we can make about zoning changes. Maybe that's outside of the purview of the report, but I think that would be really important to us. What?
I mean, I think to the extent, and I think the commercial is a really good point, and we did gloss over the commercial, and it is a fairly significant percentage, is I think that is a zoning issue. I continue to say that it's not just Santa Monica, these are mostly down zonings.
Yeah, right.
I mean, I will look at downtown again, and I have all the data, but it's really compelling that it's mainly down zoning, and again, through many communities, and so you're just getting big old houses where you had.
I mean, I guess the question would be, is there a way to potentially make a recommendation to change zoning in and around high density rent or high proportion of rent controlled units such that it would disincentivize someone from Ellising because they wouldn't be able to take as much economic advantage of that Ellis activity?
Well, that was our 1-for-1 recommendation.
Yeah, okay.
I mean, I know you guys keep wanting it to be that people are intensifying, and again, I will relook, but that just was not what came out of the
No, I mean, the 1-for-1 is not a bad suggestion. I mean, I liked what some of these other cities are doing. Nicole, what? Sorry.
I just want to be clear with the way that we're talking about down zoning. Down zoning means like you're reducing zoning from like a higher density to lower, but that's not what we're talking about here. I think the way that you're using down zoning is you're talking about just lower density, like R1 neighborhoods, right? Which is not a change in zoning, not a move in zoning to less, density or less height. You're talking about the lower density areas, which are providing for less growth, correct?
Well, I guess what I'm saying is Santa Monica does not have pyramidal zoning. So if something is zoned for 20 units the acre, you can build 10 units the acre. There are cities that have pyramidal zoning. If it's zoned for 20 units the acre, you can't build less than 20 units per acre. That's a good recommendation. And so, well, that was what I was trying to get to with the 1-for-1, is that no, in areas where you could build by zoning 4 units, people are taking 4 units out and building 1. That's what I'm trying to say.
Yeah, no, I hear that. Yeah.
Because I mean, at least, and maybe you could look into this, but I know that like a lot of the condos that are being built right now, or at least anecdotally I've heard, are these 2-unit condos where you don't have to build your affordable unit.
That's exactly right.
And, that's something that would be really helpful for us to talk about and think through in this report. If not, how do we,
and it's also what is city council's jurisdiction to potentially change any sort of city ordinance to disincentivize that, and then what would rent control board's jurisdiction be to look at our charter or any of our regulations?
Well, see, I mean, I don't mean to oversimplify it, but I really do think for your 2-unit example, which is clearly happening. Clearly happening, not just anecdotally, clearly happening, and it's obviously being done to avoid AHPP. So, I've said it too many times, I'm trying to think of a different way to say it. If it was zoned for 3 units, then by doing 1-for-1, it would have to have 3 units.
Right. That's a great, and that's a good recommendation.
To me, and so I think that actually, in many ways, just solves that question. Back to the question that I haven't resolved in this discussion is it the exact opposite happening downtown?
Yeah.
Where then people could build, they've got 4 units, but they could build 30 by zoning.
Right.
Are they Ellising to do that?
Yeah, I just don't think we're in a one-size-fits-all potential analysis situation, because we do have these as you know, we have these very distinct neighborhoods. And I also think when we're saying, okay, the majority of Ellis activity is happening in 90403, but it's also like the majority of rent-controlled units are in 90403.
No, absolutely.
Right,
No,
right.
we made
So it's
that
like,
point in the report. No,
right,
I
so
mean,
like
yeah,
potentially, like
right.
proportionately speaking, is it still the majority happening there? So I mean, yeah, those are just some of the things that kind of popped out at me. But you know, I thank you for all of your work and for, you know, your dedication to affordable housing. We definitely share that and appreciate it. Yeah.
No, and I get that, and I appreciate that.
Yeah.
No, but I mean, definitely, though, and we made that point in the report, is that it's concentrated there, and it's where 70% of the rent-controlled units are. So, sure. I mean, some of these, I get it, especially as your rent-control board, you guys are going to say, well, duh, you know, why are you wasting my time? I get that. I mean, but I do think the other thing to keep in mind is you are not the only audience. And so this context is important to people who don't have your background.
No, I hear you. I think maybe like an appendix with this information and like an executive summary at the outset, and then fleshing out of the recommendations would be helpful. And then I think it would be helpful for us if we saw like what city staff's directive to you was, because I think we were coming at it from a certain expectation, and it's possible that what the directive was from Nicole got lost in translation, and that's no fault of yours.
Well,
yeah.
I'm happy to take all the fault, so blame the fault on me.
All right. Any more questions? Okay. Thank you so very much for your
Thanks.
time.
Thank
I
you.
do have a request to speak. It's late chit, so I believe I need to ask the board if it's okay to let
Move
the speaker
to
speak.
give 1 minute.
The request was 2 minutes.
Well, I mean, it's our only speaker on the item.
It's
They
our
can- they can
only
have-
speaker?
It's our only speaker, yes.
They can have what they requested. She requested 2.
2 is fine.
Okay, is there a move? Okay, I move that we allow 2 minutes to speak. Anybody second?
Yes, of course, yes.
Okay. Anybody opposed? All right, hearing none, we will allow Ms. Jennifer Kennedy to speak for 2 minutes. Yes. And by the way, she had requested 2 minutes. Yes. Oh, and also a former Rent Control Board Commissioner, Chair, and current Planning Commissioner.
So
Commissioner Kennedy.
thanks very much for letting me speak for 2 minutes. I'll try to be fast. Yeah,
Ready to
thank
go.
you. No, I really appreciate you hearing my late chit. I formulated a lot of my comments here this evening as I was listening to this and listening to you before I drove over. So I might be all over the place, but let me just say a couple of things. Listening to you guys tonight, I'm hearing a little bit of conflation of some issues. Remember that there's 2 separate issues that you're talking about for most recently. Protecting existing rent-controlled units and creating more new affordable housing units are separate issues.
Yeah, right.
Okay? So remember that what's the zoning on the boulevards and zoning in some areas is different from what's the zoning in the neighborhoods. This issue with how many units, 4 units that you can build, of course, Kath knows this, right? Developing mitigation strategies to reduce and eliminate and incentivize Ellis withdrawals, reduce the risk is a really important undertaking, and I applaud you for doing that, but I urge you this evening to think of a couple of things. I would urge you not to make any specific recommendations necessarily to the council, or perhaps even to this consultant. If I have a handyman and I hire the handyman to come over and fix my sink and they work on the toilet, and when they're done with the job they said, but the toilet was next to the sink, I'm not going to throw good money after bad, okay? You need to think and say, wait a minute, that was a lot of money that we spent. What else do we need to do? Think about how you're going to get the job done. In Silicon Beach, maybe $38,000 can get you a lot more than what this, I don't know. You just need to think about those issues, okay? Risk factors. That is something that you guys talked about so far this entire evening. How long has the owner owned a building? What are some commonalities? You've got this reoccupancy permit, okay? People Ellis, and then they get a reoccupancy permit, okay, which allows them to put non-rent paying persons back in that unit, and then who knows what happens. There are ways you can perhaps tighten up that permit system. I know that the timer just went off, but I can perhaps try to answer some of your questions. You guys, I would urge you strongly. Everyone's going to say, we don't want to have more meetings. Nobody wants to go to more meetings. I was a rent control board member. I'm speaking in my own capacity tonight. I was a rent control board member for 8 years. I'm a planning commissioner for 7 years. I have one left. I know everyone's like, no more meetings, but we got to have a meeting together. If the planning commission and the rent control board could get together and talk about some of this stuff, boy, I mean, we would, I know that the planning commission and our staff could help answer a lot of the questions that you have, and we have our own as well. But there's a lot of conflating of issues going on, and I'm sorry for going over my time. Maybe you want to ask me questions so that I can get my next comment out.
Any questions? Yes, Commissioner Foster.
You were trying to speak quickly and stay in your time, and I appreciate that, but you mentioned something about permits, and so, the middle item you were recommending, right before the one where you said we should get together with your commission and have a meeting.
Well, I know. I really,
there was something
like
right
I said,
before that, and I didn't understand what you said.
Thank you. After an Ellis, an owner can apply at the rent control board, and your staff and your attorneys can tell you way more about this. It's in the back of my mind. You've got reoccupancy permits. So they've Ellis'd, and after a certain period of time, they want to put people back in that property, and they're non-rent paying family members or whatever. Again, you can turn to your staff and have them explain the entire process. You can see those permits. You can see them blank. You can see them filled in. You can see them after there's been a determination. And over the years, I think that there have been some that have been questionable. The real issue is one of the issues might be, well, what happens if we the tracking of that falls off?
So we track owner occupancy, for instance. We make them reaffirm after a year, and we can send an investigator if it appears to be a lapse. Are you suggesting that if it's a rent-controlled building that's Ellis, that we impose something similar for tracking from our perspective to our purposes?
Well, I've heard time and again that it's difficult to do these types of things, but
we've had a lot of success with tracking the owner occupancy.
I would ask staff about it. I would say, what can we do? Right before I came up and spoke, there was someone kind of alluded to the fact that what happens after those properties are reoccupied? Are they for example, are they reused for another use? Do they end up as vacation rentals and no one's watching what's happening? If the reoccupancy permits had different terms, if it was a different type of a contract, would someone think twice about Ellising, knowing that they couldn't do something else flying out of the rear? I don't know. I'm just saying that it is something that you can look at.
So would you propose a joint working group between Planning Commission and Rent Control Board Commission, or is that what you're proposing? Suggesting?
I don't shy away from extra meetings. I'll take them. I know it's part of the work that we do for the community, and so for me, no problem. Can I speak for the rest of the Planning Commission? Again, I'm speaking here tonight just my own personal capacity. I don't know what they would want to do, but I would say let's maybe perhaps start with convincing some staff members to try to get us together for a joint meeting and then see where it goes. Maybe there can be a subcommission or something to that effect, but I'd be more than happy to work on some of the issues. Again, for example, to address the thing that has come up numerous times this evening about replacing one-for-one. Commissioner Phyllis has been really concerned with zoning and upzoning or downzoning. How does the zoning play into it, okay? Which, of course, this firm has knowledge of. They're a boutique real estate firm. They know about that stuff. And the Planning Commission does, and of course Planning Commission staff does, and that's why we can get together. But to go more directly to the point, take into consideration something where if you have a zoning law that only allows you to build a certain amount of units upon a demolition and redevelopment, what would happen if you were to suddenly increase that amount exponentially? Is that an upzone? Is it Is it is there a risk factor there? I would ask you to consider, is that a risk factor? So where I could have a handful of M&Ms, or I could have 20 handfuls of M&Ms. I mean, I'm just saying, you need to think. So, and I know you are. I'm very, very, very impressed with all of the things that you guys have talked about tonight, and I'm so glad to know all of you and to come to these Brent Board meetings, and I feel that you guys do a really great job, and I would love to, in a more perhaps formal capacity, work together with you to try to, again, identify some of these risk factors to try to disincentivize the Ellis problem.
Commissioner Kennedy, Commissioner Flora has a question.
Yes. If we do consider a joint Rent Control Board planning meeting, how do you feel about Saturdays? Because Commissioner Terosas has a real affinity for wanting to meet on Saturdays.
Inside joke.
I remember.
I don't know if you were here last month, but she's dying to meet on a Saturday. So,
well,
would you consider it? I'm just
I
kidding.
would Commissioner Flora, I would consider it. Our current the Planning Commission chair has suggested that we have a Planning Commission retreat, and it's been recommended on a weekend. And I have to tell you, I'm all for it because there's team building exercises.
Hey, women's commissions did that for years.
Okay, thank you.
The work of the community is an ongoing process, and we do whatever it takes. And again, just really thank you so much for your time, and thanks for listening to me. Thank you for all the good work you do.
That wasn't actually my question. That was that was my joke question,
Bring it
which
on.
turned into a possibly real Saturday meeting. You were trying to get a lot of things out in your 2 minutes, which seemed really a fast 2 minutes. One of which I want to make sure I heard correctly. You, for a moment there, were warning against us making certain or specific recommendations?
Well, I'm sure.
Can you go into that?
So I heard a little bit of the beginning of your meeting, and then I said, oh my gosh, I want to go down there. And then I missed some because I was in the car, and so I'm not exactly sure how much of an introduction or certain things that you heard, but it looks to me like your agenda says that you are basically hearing the results of a study and taking it on advisement. I don't see that there's a recommendation required of you at all. And so I would just recommend personally that you don't go too far afield because
it wasn't in the agenda. I get what you mean.
I mean, when it gets into zoning issues and what other cities have done with their zoning issues, I know this is bigger than it looks.
Yeah.
There's more to it.
Okay, I understand what you meant now, and I appreciate it. Thank you.
Yes, thank you.
We
Point well
appreciate
taken.
you being here.
Thank you.
And also, I would definitely
appreciate you being
support
here.
a joint meeting
Okay, cool. No, I think it's a great idea.
on a Saturday. Just kidding.
Thank you very much.
All right, thank you.
Commissioner Kennedy.
Thank you, thank you.
Okay, that concludes item number 12. Moving on to item 14, this is a board discussion item, and at the request of Commissioner Phyllis, the question posed was if the board enacts regulations permitting landlords to pass through to their tenants a portion of earthquake retrofitting costs, to what extent, if any, should existing pass-throughs for local assessments be limited? I don't know if there's a staff report on this. So Commissioner Phyllis, that was your issue? Go ahead, you have the floor.
So this item originated, I sound like Zeph. This item originated when we were discussing at our last meeting contemplation of earthquake retrofitting pass-throughs. And the way that it arose, I think, was that we were concerned that if we did not enact pass-throughs that supported the retention of, if we did not enact policies that supported the retention of current landlords, that buildings would turn over, and then the other pass-throughs, which are conceptually distinct and unrelated to seismic retrofitting pass-throughs, which is for a very specific and narrow capital improvement, those pass-throughs could actually, in fact, have really negative impacts on tenants because, of course, when these buildings turn over, the pass-throughs are reassessed based on the new property value. So we're seeing drastic and massive increases. you know, to the tunes of hundreds of dollars, which is really, you know, a matter of homelessness for some tenants. So, you know, I don't think we need to have a massive discussion tonight. What I would like to do is direct staff to come back at our next meeting with proposals to address, and is there an item, a speaker on this item?
There actually, it's my mistake. I am
Sorry.
sorry. Yes, there is a speaker.
Okay.
Do you want
Yeah,
to
so
pause?
I'll yield to the speaker and then
Okay.
we can proceed.
Very good. Excuse me. Michael Millman, you have requested 3 minutes. Forgive me for not seeing your chip.
People do that all the time.
Yes, good evening, Michael Millman, M-I-L-L-M-A-N. This really, I don't really have a dog in this hunt, but historically, I see this as betrayal. 20 years ago, you go to the landlord community, the realtors, the developers, and you say, look, we want to enhance education, the schools, and we want to build better schools and do good things, so we're going to put up a bond, or we're going to put up a parcel tax. Could you landlords support that? And SMER said yes, and we'll let you pass it through. And Chris Harding and his wife said yes, and we'll let you pass it through. And Patricia Hoffman, whose own children went to Santa Monica School, said championed it, cheerleaded it, we'll let you pass it through. Because after all, the tenants who live in those units will be sending their children to those schools that'll be enhanced, not the landlords who don't live in this city. This is an investment for them. So that was the deal that was made. Now to betray them after you built those schools and added those rooms and say, no, we're going to change the goalposts. We're going to change the goalposts and make it different. I think that's a betrayal. No tenant in my buildings and no tenant in the landlord groups I'm involved in, which are 3 of them, have ever come to Michael Millman and said, we're upset with paying for the pass-through. Not one. Not one. Not one. That's not anecdotal. Those are my tenants, and I've asked them. Not one. So I think it's a betrayal. I think it's a betrayal, because we in good faith made the deal. We don't like parcel taxes or bonds, but we were promised this will be the deal. It'll be passed through. Thank you, Mr. Chair.
Thank you, Mr. Millman. There is a question from
Just out of curiosity, how many tenants do you have?
in Santa Monica, California, I think we've got about 15.
Who's we?
Myself, my family. We
Okay.
have 15.
I wasn't
we
sure
have
if it was
units.
a company.
Pardon me?
I just wasn't sure if it was a company.
No, I don't. Nobody, no company wants to be with me.
Okay. Thanks for clarifying.
It's like that quote from it's that quote from Woody Allen. I wouldn't want to be a part of any organization that would have me as a member.
Oh, was that?
Annie Hall. Anyway,
Oh, that was,
Annie Hall reference. Was there any? There's nothing else.
Can
okay.
I finish?
Yes, you have the floor.
Thank you.
again.
Okay, so, Mr. Millman, I hear what you're saying, and you know, I want you to have some assurance that we are trying to think about this in a very thoughtful way, which is why I would direct staff to come back to us with some proposed amendments to address the current situation with pass-throughs, and specifically to think of ways to mitigate the impacts when a building turns over. Because that's where, whether it's a dollar amount cap, whether it's a percentage increase per year cap, there's got to be some way to address these pass-throughs that's fair, and equitable. And I want to make sure, I know this item, I want to be super clear on the record. I know this item originated in the context of seismic retrofitting, but those pass-throughs are conceptually distinct, separate, and should be dealt with in a completely different context than the pass-throughs based on land assessments. And so I want to be super clear moving forward that, my interest really lies with the pass-throughs based on land assessments.
Can I make a question?
Okay.
Is it for me or for staff?
Go ahead, question.
I also would like to know what other jurisdictions are doing pertaining to this as well, just like a study of practices from other jurisdictions. Am I allowed to direct that, Nicole?
Yeah, sure.
And then potentially options for us.
Oh yeah, I would like specific language for amendments to regulations, please.
Any other comments from other commissioners?
Yeah, can I ask for another item?
Just,
We're still on this item.
Okay.
Go ahead. Commissioner Flora.
just want to support the request. I live next door to a building that was recently purchased. Only 2 tenants remain out of 6 units. I don't know what they're being asked to do with regard to property taxes, but the other 4 empty units aren't paying any of the pass-through. So I really think that this market with these purchase prices is really hitting a lot of our constituents hard who are seeing these property tax pass-throughs. So I just want to recommend the sentiment and the recommendation be made that we explore this and we talk about it as a board and as a community.
Okay, thank you. Commissioner Foster and then Commissioner Trosis.
Just so for the public's benefit, I'd just like to clarify that in my opinion as a commissioner of this board, it's not about deal-making or any past regulations that were passed. It's what this current board seeks to address or to identify in the community. It can't be said that random public constituents have come to the microphone and have brought specific examples to our attention. It's not a witch hunt. It's not a goal of ours. It's things that are being brought in very specific instances and very specific buildings are being made examples that we can't ignore. So we've been asked by the public who elected us to examine. So we are not saying at this point what, if anything, we would or wouldn't do. We are simply examining the current status of these pass-throughs and their impact on the community and on rent-controlled housing and on our goals to preserve rent-controlled housing and affordable housing. So I just wanted to clarify for the public that it's not breaking deals or breaking trust. It's about taking our legal obligation and when constituents ask us to bring something up and analyze it, then that's what we do. So that's the genesis.
Commissioner Trosis.
I also take issue with the term deal now that you're bringing that point up, because that implies that I received some sort of consideration in exchange for me deciding something, and that's not what we do here. We don't make deals, if you will, backroom deals. We do what's in the public's best interest, as we've been elected to do. So in any event, I support Commissioner Phyllis's item or request of staff. As we saw in the previous report from Kaiser Marston, they let us know that median home values in Santa Monica have increased 60% between 2009 and 2017. I would assume that entails multi-unit buildings as well. And when buildings are sold and property taxes increase, and we have constituents coming to us, claiming that they're going to have to move out of their buildings because of these pass-throughs, it's incumbent upon us to at least study the issue. So I support Commissioner Phillips.
Okay, thank you. If there's no further discussion on this item.
I just have one other comment kind of pertaining to the item, but a separate issue.
Okay, go ahead, give it a shot.
Yeah, I was wondering if it would be possible for staff to come back to us at the next meeting with an official written up like board letter or resolution for city council officially asking city council to put forth financing mechanisms for earthquake retrofitting. We've heard now in the interim over the last month from our last meeting that this is a significant concern, especially for smaller landlords. And city council did not come forward with any sort of recommended, I don't even want to say recommended, but menu of options of affordable and accessible financial packaging for landlords who need to get this done. We've said multiple times we want to incentivize landlords to get the retrofitting done because we want to keep our buildings safe. And to me, part of that is making sure that there's a menu of options for them to attain safe and affordable financing packages. So, I mean, I've talked offline with some of our city council members, and I think it would behoove us to send them an official recommendation because, I'll just stop there.
Okay. Council, is that something that can be done?
Yes.
Okay, very good. All right, moving on to item number 16, adjournment. Is a move in a second. All in favor?
Aye.
All any opposed? No. This meeting is adjourned. I will let the audience know that next month's meeting is December 7th, 2017 at 7 p.m. at MLK Auditorium at the Santa Monica Main Library. See you then. Thank you. Have a good night.
Tell them that we're very